The point of this panel is to start a discussion that you may continue later on and to give you some clues as to where to look into as you go fully independent. Because, you know, every developer wants to go independent, and it's important to know the risks that are connected to this. We start by discussing what exactly is IP, as IP is becoming the cornerstone of our business. And just like any music band, let's say the Beatles, which owns its copyrights, you probably want to own your own copyrights and you want to own your own product and your own future. So Katya, can you briefly cover what exactly is IP when we say IP, intellectual property? What does it mean?
Before I start talking about IP, I wanted to let you know a little bit about my background. I work at Wargaming now. Wargaming is a big company, and we have lots of different experience working in different markets. But before that, I worked with publishers and developers in games industry, so I know what I'm talking about when I'm talking about developers and how they perceive and how treat IP. And
so you have a history of representing developers?
Yes, I have history of more than 7 years representing developers, from big ones to small ones, one-man team to 3,000.
And do you like working with developers?
I adore it. So when developers come to me, it's always talented people. I love them to work with them, but basically they don't know
do they always
anything.
Pay?
They pay.
Okay, good.
Otherwise, this is not very important.
So once you've dealt with your background, what is your background?
Currently, I work for Sorainen, which is a relatively big law firm for Lithuanian markets or Baltic markets.
A few hundred lawyers.
A few hundred lawyers, 150. I work with communications, media, technology sector. I was previously freelancing as IP IT lawyer for smaller startups and IT companies, and my involvement with video games really started relatively recently in May last year, when this new wave of game developers started moving to Lithuania. So,
and we brought our problems with us, right?
Yes, and they brought their problems with them.
So going back to the question, what exactly is intellectual property? And when we're saying, you know, the developer wants to own its IP, what does it mean? What exactly should the developer own?
From legal perspective, everything that developers do, they're creating IP. So that is why we're all talking about owning IP and how it is important to actually control IP. You do not give control to somebody else over this IP. And
well, what's exactly this IP? Because remember, we had a conversation with the studio, and the studio said, well, I own my IP. And we said, what do you mean I? And he said, well, my studio. And we said, well, you've got 3 companies. So who owns what? And he was like, oh.
Basically, there are 2 questions. What exactly you own and who owns that? And another question, and do you really own your IP or not?
So what's IP? It's a copyright?
No, IP, basically it's intellectual property. And speaking about games, games are very complex subject matter that unites many kinds of IP rights in them. So for developers, what they create, this work, there are several IP rights available to protect this work. And among them, copyright, patent, design rights, trademarks. We're not going to talk about them here, because the most common way to protect games is copyright. Vytė, can you talk about copyright?
Copyright is good in the sense that if you're young and you don't have a lot of money, copyright is good because you don't need any registrations. Copyright protection starts working, and it exists from the moment of creation of your work. So if it's a storyline, a character, gameplay to a certain extent, software, you don't need to acquire special protection.
You don't need to spend any money.
You don't need to spend any money. The complication is that it's often hard to prove that this is your copyright, and this is your work. So what it's really important throughout the process is to properly document your what you create and what your team creates.
Especially as we move towards games being a service, and when you were launching the game in a box, you could say, this is my game right here in the box. But when you operate an online game which is changing every week, what exactly do you own?
True. Adding to the copyright protection, I guess we agree with Katya that trademarks is a good tool. It's relatively cheap. You have a piece of paper that says that you own this trademark. And in games, you can trademark quite a number of things, starting with titles, character names, certain little things that certain visual things in games. And it's easier with evidence if you come to enforcing your intellectual property rights. Trademarks is a good tool.
So trademark is the most obvious, copyright is the easiest because you don't have to spend any money to actually own things. What about design rights and patents? We are not going to talk about them, but why?
Before I talk about patents and design rights, I want to say that trademarks and copyrights are most common ways to protect certain assets that are in the games, but they protect different things. So you need to seriously consider what you protect with what. Talking about patents and design rights, so you can find in the games those assets that can be protected, but those IP rights, but they are much harder to obtain. You need registration. You need registration to this right to exist in every jurisdiction. There is no some global IP rights, particularly there is no global patents and design rights, and it's expensive.
What about the cost of registering a trademark? What, roughly, is it $5,000, $25,000?
It depends on jurisdictions.
Yeah, but let's say globally. I'm a developer. I have something, a really cool name. I'd like to protect it. Should I budget what? 10,000?
No, it's not going to be
more.
10,000. It's more.
For example, European
100,000.
Community trademark, which gives you protection in all European countries and it's unified. The filing fee is 900 euros. Then you add the cost for lawyers, and it ends up a couple of €1,000, but that's only Europe. Then Russia is expensive, Canada, US, you will probably be filing an international trademark application with designations to different countries. Then once the process becomes national, you will get rejections, and you need legal representation. So roughly starting with 50,
10,000.
If you're really global, it's even more.
It's 100,000.
I think once I spent $7,000 in registering a trademark.
Where?
Internationally, through an American lawyer. It was like 7,200. But I mean, I don't want to say that it's $100,000, but it's relatively inexpensive.
Relatively to patents, yes.
What about patents? How much money are we talking?
Recently we calculated that patent protection in 10 countries, let's say European region and Turkey maybe, approximates around 50,000 euros. It sounds a lot, and it's true, and most often you don't need patent protection in games. So you should keep in mind that it exists, but don't go blindly into it.
It's too expensive. Okay, so going from the cheapest to the most expensive, you can go from copyright, which you don't have to register, to trademark, which is $10,000 more or less, maybe more, and then patents, which you need in extreme cases that have limited applicability, and they're changing at the moment. Is that correct?
Yes, it is. Patents are available in America, and I believe there is a talk tonight at 16:30 about patent protection of the games. But I can say that right now it is possible to register a patent for a gameplay in America, but the tendency is different now, and soon it will not be available for games, and moreover, what was registered will be invalidated, I think.
There's a lot of patent wars, and there was a lip sync that got patented and they've lost. There was a trolling company filing suits against a lot of studios. Anyway, we're going to focus on copyright protection. We're going to focus on, mostly when we talk about IP rights, we're going to talk about copyright rights that you have to your work. Let's start with the first case, which is a studio is working on video games for 5 years, 6 years. It's successful, it gets some traction, and the studio is getting ready to get investments. The investors come in and they would like to see what?
Oftenly, they want to see IP portfolio that you own, because when they invest money into the studio, they want to see that you own certain IPs which they are interested in. And
how do you prove? Like, let's say I'm an investor, you're a studio, I come in and you say, I am the developer of, Bob the Snail Goes Zombie, and I'd like to put $1 million for that, or for half of that. How do you prove that actually I own this?
I may
IP?
sound obvious, but agreements, contracts that you sign with every person that is involved in creative process. And this might sound obvious, but still lots of developers just don't do this. I do not understand why. It's such a simple thing to do.
They're too focused on creating value,
Yes.
on creating things. But
And in most cases, sometimes you will not need those documents, but when it comes to a situation like dealing with publishers, dealing with investors, when there is a conflict within the studio, when you want to create a sequel, but you, so in a situation of conflict or some questionable
or when you
situation,
want to take money. I mean, whenever there is money,
when there is money
pressure.
involved, also you need documents, and in most cases, people really sorry for not paying attention to this issue in the very beginning.
Yeah. Let's not moralize too much. Developers are developers.
No,
They're
it's a
like
fact.
children. You have to be forgiving.
Yes, we are.
What do you think, Vytė, in your opinion, what is enough if a studio wants to receive investment? And my studio has developed 3 different games with 3 different characters. What will investor want to see before they give me money?
They will ask questions, obviously, who owns the IP. So if you have at least a trademark registration or 2 to show that's helpful. And then I would say not necessarily all the contracts, all the employment contracts. Sometimes we use declarations that the developer declares that it really owns the copyright, but you have to realize that doing this declaration and presenting that you own the IP, it's in your own best interest to actually do it. So it's very important in what you have in your contracts. If we are talking about employment contracts, within the EU, copyright laws are pretty similar. And the requirement in very many countries is that you define the objects of IP quite precisely, and then the list of rights that you are transferring. Are you allowed to sublicense? Are you allowed to receive payment for exploitation of your work? Otherwise, if you don't do these things in the contract, then the statutory presumptions apply, which are not very favorable for the developer. They usually protect the employees.
So what you're saying is that I have a game which was created by my programmer, but he acted as a designer in this game, and I assume that I own this game too, but in fact, I own his programming work, but not his design work. And when I will sell my company or my IP, his wife will come to me and she will say, you don't own that, because he created this on his own time, even though he was using your machine and your office and everything. Katya, how often is that you start working with the studio and the studio says, oh, we have no problems about ownership, we all know each other for years, and then once the money comes into the equation, they change their minds?
In 99% situations when developers come to me, they think that everything is taken care of, but in fact it's not true. Even agreements between core team is non-existent between partners of the studios. And when it comes to conflict, they can't agree. When there is money at stake already, and this is visible, that the product is going to be profitable, this is the point where all the problems are. If before you can negotiate it, you can have agreed on everything, on every term. Now it's becoming more and more complex.
So before you would say, you know, he's like my brother. You know, we share everything, and he has complete trust in me. Therefore, he will not object to me owning the whole thing. And maybe he will not. But if then you say, and I'm going to get $1 million, then he's going to have a problem with that.
Yes, and what most of the developers do not understand is that IP goes and money are not connected. So you can have revenue share in the project, but you can not own IP. And
you mean like you hire a talented guy and you say, I'm going to pay you 5,000 euros a month, plus you get 10% of the profits. It doesn't mean that
this guy will own IP
10%
as well.
Of my IP.
Yes, and I would recommend if you are the owner of the studio, whatever it is, it's maybe.
If you're not the owner, just stop listening now.
If you're owner of the studio, I recommend that you gather IP in one place so that it is visible where it is accumulated, and you can motivate your people, those who create stuff, by percentage of the revenue once the game is successful. But it doesn't mean that you need to give them part of the IP, because if you want afterwards to do something, to develop a sequel, to produce movie, to create a cartoon, to do merchandise, you need to be sure that you're the one who can deal with it, and you don't need to ask anyone else a permission to do something with your property.
I think there was a game called Blade Runner based on the movie, and I think that the movie was running out of budget, so they gave ownership to different actors. And as a result, a bunch of different people ended up owning a little part of the project, and before the game could have been developed, they had to clear all those rights, talking to all those little shareholders. So you don't want that. You want to be able to have full control over what you will do with this project, even though in parallel you will be paying money to certain people, and it's okay. I mean, revenue share doesn't mean ownership of the property.
One other example is where certain people, let's say programmers, are working part-time for several different companies. The question becomes if that guy is working, is being present in the other company's office, working on that other computer, but working on your project. You might end up actually a third party, another big company owning part of the IP to what you think is your IP. That's a risk, and it's hard to fight the claims of the bigger guys.
Because the thing is, you think you've got a great relationship with the artist and programmer, and they will not cause any trouble to you, but they would work for an American company which will own all of the work they produce in the office. And they would produce your work in this office. And so once you launch the game, this company will wake up and say, you know what, we own that. You will not be dealing with people you know and trust. You will be dealing with someone who's a third party, who has money and lawyers, and who wants to actually take a significant cut of your revenue. And this is something you have to be aware when you hire freelancers who are employed somewhere else in different jurisdictions.
I think Sergei is touching a quite interesting topic about differences from different jurisdictions. You mentioned the States, and laws in the US are different from Europe, apparently. And one thing that we're noticing that, for example, Lithuanian studios, right? They often come and say, well, we have this contract and it's not working. The studio that we commissioned is not delivering. And we are looking at the contract, and it's copy-paste from some UK contract, which uses concept of warranties, indemnities, and in Lithuania or other continental Europe, there is no concept like this. So when you're using a contract from a different jurisdiction as an example, it's fine, it may be okay, but you have to keep in mind that certain legal concepts have different meanings in different places. So if you're working with people from the States, Russia, Europe, keep that in mind.
Another problem with contracts come from that they are not specific enough. Some of them are copy-pastes from different contracts, and it is really, really hard for lawyers to establish what exactly is transferred, which kind of rights, and to what exactly subject matter. Sometimes it's impossible to establish, and in some jurisdictions these generic agreements will not be valid even, because the court, for example, they will not be able to establish the subject matter of the agreement. What was the intention of the party? What was exactly they agreed upon? Which rights and to which game it was
I think the most common question that lawyers receive is, can you create a standard contract for me? And the honest answer is no, because there's no standard contract that'll take care of every situation that you encounter, even if it's a little bit different. One of the cases that I was working on this year involved a Swedish company copying an American contract and saying that this is going to be based on Swedish law. So half of the terms and clauses in the contract, they were thrown out during the arbitration process because they were American, and it doesn't work in Sweden like this. Another contract was based on laws of Germany, but the argument had to happen in Belgium. So you're dealing with like half of that contract doesn't work because the law is German, and German law is different. So what you have to, I think, like if you take away a simple idea is you do not copy-paste contracts from one country to another, from one jurisdiction to another, because every case is different, and the laws of that country may override whatever you put in the contract. I don't know if you had any cases where laws would sort of squash the clause in the contract.
No, it's everybody knows this situation with French law that does not allow assigned moral rights to the copyright. So whenever you publish a game from a French designer, for example, you need to mention that guy everywhere because you are not allowed to assign.
It's good to be French.
Yeah, it's good to be French. In America, there is another concept of work for hire, and basically there you can have moral rights assigned to a company that owns IP. But in continental Europe, this work for hire concept doesn't exist.
But you can still copy Californian contract and consider yourself safe.
Yes, you can, but just statutory law will apply, and you don't want this to happen.
Don't understand us wrong. Some contract is better than no contract at all. But then if you're already so advanced that you're having contracts drafted, you may as well spend some...
red wine over vodka, but then within red wine, you can have like,
Yes.
20 euro bottle or 1 euro bottle. The other concept I wanted to raise is when you work with freelancers who contribute to your game, how specific should you be in your agreement with these people about what you acquire? Because there was a case when one composer created music for, I think it was a casual game, and the studio released the game and everybody was happy, and then the studio moved the game to a different platform. And the guy came over and he said, I haven't sold you the right to use my music on Macintosh. I only gave it to you to use on Windows. And they said, you know what, we think we own the whole thing. We can sell it to play at funerals. And you cannot say anything against that. And they had a big argument, and when they looked at the contract, it didn't say anything. It just said, I'm creating the music, we're paying you money. That's it. There was no discussion of what exactly, how big is the scope of rights that he gives away. So you don't want to be hit by that. Like, how specific should you be?
If you're a composer, you want it to be as vague as possible, because the law usually protects the weaker side, which is usually the author. If you're a developer and you're a company acquiring rights, you not only you actually need, and it's very important to have it very specific. Define the work to which you're acquiring rights. Define the list of rights that you are getting. In the US, the general assignment of rights works and it's common. In Europe, it does not. So if you're dealing with a French composer, not only you will have to mention him in end credits, you may not necessarily acquire everything, all the rights to the work. So the advice is really be specific. It's easy to do, it's not hard, keep it in mind and be consistent with it.
Because the risk here is that you have your game, it's successful, Sony comes over and says, can you make this game for PlayStation Vita? And you say, sure, we are using Unity, we can make it happen. And at this moment, you realize that maybe not all of the rights to the content in the game have been cleared for use on consoles. And some people at this moment will already see that your game is super successful, and maybe they will want a bit more than you could have paid before. Maybe they will, even be in conflict with you. One thing that maybe people don't realize is that you trust certain people that you work with. This is a given. But there is a little loophole, is that people fall in love. And you cannot control whom your colleagues will fall in love with. And we fall in love based on different qualities of other people. And then, people divorce, blah, blah, blah. So you can have a great relationship with your partner, and you feel that you don't need the contract. And then your partner falls in love with a girl from a different background, and she will come and she will say, you know what, I think you have a problem with my husband's work, because he's not paid well enough. And then you'll be in court. And you'll have great relationships still with the guy, but this is a story not only from video games business. A friend of mine is publishing artwork, lithographies. And one of the stories that recently happened is that his bright author in Germany fell in love with a girl from a very strong family. And that girl came to him and she said, you're not paying him enough. He has to get more recognition. He has to get this and this and this. So all he had to do was he terminated the work completely because he couldn't work in this new relationship. And the guy didn't change, but the relationship changes. So you have to always think that it's not only the people that you work with, it's the whole environment around them that may affect and create new risks for you. Let's talk about publishing with publishers and platforms, and in which situations the platform or the publisher will co-own your work. Do you see this as a common thread?
7 years ago, it was a trend that publishers wanted to have control over IP. They paid money for game to happen to IP, and they wanted to control it. Our recommendation was that developer keep control, but sometimes it's not possible. Developers sometimes don't have this negotiation power at all. But the thing is that you need to understand what you are doing, and in most cases this is not true. And if you assign the rights to your IP to publisher, it should be knowingly. So you should accept this risk yourself. But it's not the case all the time. And then after the digital platform appeared and self-publishing options appeared as well, this trend seems to vanish somehow. But now, when it is hard to go to App Store without publisher, as I see it, this comes again.
It's easy to go, it's hard to be successful, but
yes, easy to go, hard to be successful, and again the publisher in place, and this trend seems to reappear again. And more and more I have contracts that assign rights to publisher or control, or give control over the rights, like 50, 20, 30%, but to me it's the same thing. Basically, you can't do anything with this IP that you created without agreement with publisher.
How
you lock it.
How can you deal with it? Because obviously, the publisher will, invest considerable amount of money into launching your product, and they don't want you to take that product, that investment, and go to a different publisher or do it yourself.
Yes.
So they want to secure the investment. Do you have any strategies, like, except for writing everything down specifically, who owns what, so you don't have any misunderstanding? What else can developer do to secure that they don't give more than they should?
It really depends on how much negotiating power you have, and sometimes you actually have more than you think. There are ways of being creative how to distribute these rights to this added value to the new version, for example. Again, going back to the point that IP does not necessarily equals to money. You can try structuring the deal so that they get more revenue share, for example, but you get to keep more of the IP. Another thing you can possibly think of is give them the trademark to the game, for example, but keep the rights to the very content of the game to yourself. So if, for example, the game becomes really successful and the publisher then wants to hire another developer, another studio to make a new version of the game, they can do it under that name. But if you're a genius and your game is really good, you can still use the content of the game.
So
and
basically,
the game itself.
if you're doing a little game called whatever Saga, you want to be able to do the sequel, maybe calling it with a different name, and the publisher will be able to use another Saga without hiring you necessarily, because they will own the trademark, and that's where the money goes normally. And the argument is generally that if your game is great, then it doesn't matter what the name is, so you'll be able to sell a sequel without the problem. If your game is similar to many other games, then it's really the trademark, the name, the title of the game that's been boosted by the publisher's money, and so the publisher should have control over that, because then they can pick up a better studio than you that works cheaper, faster, and is easier to talk to, and they can do a sequel. What about...
I can say that if you assign part of your IP to a publisher, it means that his contribution of the publishers should be significant, and you should value that, and it should be knowingly that you do that, and you understand.
Like you exchange control for investments. If there is a significant participation from the publisher, if they're sending over a producer, if they're putting tons of research, then you should accept that they also want some control. But if they're not doing it, if you're just picking up the game, then maybe not. Yeah,
another advice would be to have very detailed exit strategy. If publisher do not perform as you wanted it to perform and he promised to perform, you need to be able to get control of your rights back. Because if you understand that publishing is getting away control over your creation, you understand that you need to make everything possible to get control back when you're not satisfied with publisher's work. And this is what we lawyers do normally.
One of the recent cases, I think, that you had involved a developer who signed off the rights to his game for 90 years.
70 years.
Yeah, 70 or something, until he's dead and his granddaughter is dead. And he couldn't do anything because the publisher decided that, they're not interested in exploiting this. So the game was locked in limbo. There was not a lot of money, there was just a little bit of money. But the developer couldn't do anything because there was no exit strategy in the contract. It just said, I give over the rights for 50 years after my death or whatever, and I take some money, and now the publisher controls it, and that's it. And you can't do much in this situation. You just lost your IP.
I think it's essential to establish in the agreement from the very beginning this criteria that you want publisher to fulfill. If they are not fulfilled, then you can deal with it without going to court.
It's also asking yourself the question of what happens if not. For example, your contract may say a publisher should do this and this, or a developer whom you hire should do this and this. And you should ask yourself, what happens if not? Like, what happens if they're not paying? And if the contract doesn't say this, then it doesn't exist. Because, you have to go to court, it'll take you 6 months and 20,000 euros to file a suit, and just too much to bother.
Don't go to court.
Well, go to court. I mean, I love going to court, but it's not cheap. It's expensive fun. Let's talk about consumer protection. So a lot of developers who operate on their own, they're now going to Brazil, they're going to Germany, they're going to Japan, and my understanding is that not very many teams understand that maybe before you hire a PR agency in Germany, you should hire a law firm in Germany, because maybe with your PR campaign, you will shoot yourself in the leg. What are the common risks in entering new market?
I would say it's a common risk in entering especially European market, because consumer protection law is strong and extremely strict and protects consumers by any possible means. And if you sell something to consumers, it means that consumer protection law applies immediately to you. And basically, you need to have, under the European law, you need to have end user license agreement, which has fair terms. And if you don't have those fair terms, governmental organizations can come to you and fine you for that. And what is fair terms and what is unfair terms? It's a big, big question. It's not solved in law, and basically you need to think and find middle ground and some reasonable solutions and hope that they will not come to you.
Because it's a very common situation where a developer from the States starts to sell something in Germany and they would just slap Californian end-user license agreement that will say, you know, I agree to this and this and this, and then in capital letters there's 2 pages of text that nobody reads. But if you look from the consumer protection point of German population, you look at this and you're forcing German consumers to agree to something that they don't understand, that is not fair, that is not based on German law. And they're going to fine you, they're going to basically do bad things to you if you will do this. What about advertising?
Vytė, you wanted to add something about consumer protection?
Yeah, go ahead.
It's all connected. I just wanted to say that exactly the point that what's considered fair in the US is very far from the fairness concept in Europe and European consumer protection laws. And the same applies to advertising. There is a case law being developed concerning the free-to-play games, for example. You cannot, there is a very thin line whether you can advertise your game as being free to play. For example, it's in theory, it's free to play, but if it's too hard, for example, to pass one level, then it's not free to play under UK law or German law and in many other countries. So you really need to be very careful of how accurately you advertise your game. And the products that are within your game.
It's generally a good idea if you're going to spend 20,000 euros on a campaign in Germany. Maybe you should spend, 500 euros on having this checked by a lawyer to make sure that you're not using something that's not allowed in this territory. Or if you're going to Kickstarter, you don't want to have a class action lawsuit against you. So you want someone to read through your sort of description of the project, so nobody can really have a good chance of taking you to court, even if you don't deliver.
Another thing that is very important from the European perspective is data protection and privacy. There's this ongoing joke with our colleagues from Germany that Germans actually invented the data protection law. And it's true. And so if you're entering European market and if you have cleared yourself with German data protection laws, you can be like 95% sure that in other European countries you will be safe. But it's important to know because it's very strict and the fines are very big, so there's big risk of liability. And you have to keep in mind that you cannot process personal data without the consent, so you need to structure your terms and conditions and privacy policy so that the consumer can actually actively express its consent that you will send them direct marketing.
Because a friend of mine was about to take all the customer support email addresses and just send them a promotion for his new game. And we said, you cannot do this because these people, they wanted help. They didn't agree to being, sent informational materials about your new title. And he said, well, I don't care. But the reality is that they can file a suit against him or they can file a complaint in their own country. And then you have to deal with the agencies in Poland, in Germany, and other. I think you had the cases where some of the studios said, oh, we don't care, it's somewhere. Like, let them come to us because we are based in Ukraine or we are based in Russia. And whatever, so what, the Germans are not happy. Let them be unhappy. But what happens if Germans are unhappy and they go to court and they win?
Now, Germans can go to court at the place where they reside, where they live, basically in Germany. And in most cases, those decisions are enforceable in other jurisdictions. If you're talking Russia, Ukraine, you can enforce them there.
And then you go to Gamescom and they arrest your computers.
I wanted to mention, I forgot what I wanted.
It'll come back. But the thing is, what we want to say is when you're dealing with consumer protection, the risk is that you will have to respond in the jurisdiction where there is a problem. You can no longer go back and say, well, let them come to Kiev. They will not come to Kiev. They will have a decision in Hamburg, and the next time you travel to the European Union, you'll have to do something.
No, I wanted to say that if you publish through App Store, through Facebook, through any other platforms like this, all these questions are taken care of by Facebook, App Store. But this all applies to you when you decide truly come independent, self-publish.
Like you open this little page where you say, you know, send me money through PayPal, I'm going to send you the key. That's
this
it.
starts immediately.
Like, this is
to
the line
apply
you've
to.
crossed. You start having nightmares and everything. So this is pretty much everything we wanted to tell you. If you have questions, we have 6 minutes for questions. If you want to ask questions, just say who you are and then what your question is. So you have first question. There's a mic.
So my name is Saab, I'm from Nemesis Games, and I would like to go back to the part where you were talking about the employees and the rights that they have to hand over to the company to make sure that you actually have those rights. And could you name like the most common 5 rights or the rights that we have to go for? Because I never would have thought that they actually have to hand over sub-licensing rights as well. So are there any more tricky ones that we should know about?
I think it also depends on the passport of your employee and the country where the employee is based and where you are based.
General European employee.
There is in most of the European copyright laws, there is a list of rights. For example, in Lithuania, it's like 9 points. So what you do is you have to make sure it's there. It's the right to reproduction, copy, translate, adapt, publish, make it available publicly on the internet, etc., etc. So also sub-license is important, and receive money, receive payments for using those rights. But it really depends on specific country you're dealing with. So you need to look at the particular list of that country.
Because something I came across in my own practice is we used to hire actors to do voiceovers, and at a certain moment we didn't sign any paperwork and everybody was friends. And then once we decided to do the paperwork, we came up with this form that said, you know, we can use this voice in advertising and promotion and this on television and film. And quite a lot of actors, they were like, no, you cannot do this. Like, if you want me to do the ad, then you're going to pay me 5 times more. And we said, well, this is just a theory that we can use a trailer with your voice on the radio, and this is going to be advertising. And we had to overcome this problem of actually explaining to them that, yes, you're giving away this and this and this and this, and otherwise we could have a problem.
And it's also important to define the term for how many years you're transferring it, and the territory. For example, under Lithuanian law and many other European country laws, the rule is that if there is nothing in the contract saying that, there are certain statutory rules that start to apply, and they are never favorable to the employer. They are more favorable to the employee. The exception is software and programming. In most countries, the rules are that if you hire a programmer, and his title in the employment contract is a programmer, then the employer actually owns the rights. But again, if he is a programmer / business developer, cleaning lady, you might potentially face the risk that you don't own the rights.
And again, the more specific you are, the better. That is why it's important to work for us lawyers, to work with business development and understand how exactly you plan to use these rights. And the more specific ways of use, although it does not correspond to the law as it is per se, like this list that every law has, the better. Because when you interpret, so the contract is not being read only by lawyers, but also by non-lawyers. And the more common words, common ways to use, like using advertising on TV, on streaming, whatever you want to acquire from a person, the better. So if it's a list for 2 pages long, then it should be like this. You avoid interpretation in the future.
It's good, because when the conflict happens, you go back to the document and you all are surprised. We're like, shit, I didn't think that. I mean, who could have thought that I forgot to put board games? But in fact, once you launch the board game, people come back to you and they say, well, we never gave you the right to do board game with my art. Or, the other way around. Do we have, I think we have time for one more question. Yes.
My name is Arman. So I have so many questions, I don't know which one to ask.
Well, they will be available after this panel, so you
All
can
right.
like.
So I want to ask you to kind of teach us to swim, right, instead of saving us all the time. Here is the problem most of us who are indie developers or small studios are facing, right? We have a ton of legal questions. We also have a whole big territory of legal questions we should be asking what we don't even know about, right? And we can't afford a very expensive lawyer, right? So the question is to you, like, what do we do? What would you recommend to us? How do we even approach this whole topic? For not much money, we have more time than money, most of us, right? And please be specific in your answers,
Also, you can
as
get
much
a-
as you can.
You can get a legal degree if you have time.
I would say, I don't know if it's specific enough, I would say build a relationship with the lawyer. Because, for example, for me, what is important from my clients is that they take time to educate me about their product. The more involved they get into a particular project with a particular developer, the more I'm willing to invest my time, and then I can also advocate you as a client within my firm that this is a good investment project, this is a good PR option, we should really help these guys, they're going to be rock stars in the future. So one option, one way of looking at it is building a relationship.
Yeah, like you have to be nice. You have to, you know, you want to take something and you can give something, and the better your game, you know, let's say Jakub from Amanita Design will call up a firm. Actually, that was the case. Once we had a case with Jakub on the same side, and there was a big law firm in the UK who called him up and they said, we love your games. We adore Machinarium. Can we represent you for, I don't know, 50% discount, and we'll bill you as little as possible. We just want to work with you on your game. So that's the case where existing relationship is already influencing your communication, but you can also build a relationship with a lawyer in your city or, you know, whatever. Who's a good client for you? Like, would you agree to educate a client?
For me, it's the great client, not the one who pays on time, whatever, but the one who values your work and don't think that a lawyer's work takes approximately 15 minutes.
Takes 20. 20.
Takes 20, yes. This is common thing that it's nothing to do, just read the agreement and sign. Clients underestimate some work. So I love those who value my work.
I know that there are law firms, especially in the US, who take on young developers or IT startups for an equity share. I wouldn't be sure I would like to accept a lawyer as a shareholder.
It's against
in my
the rules
project.
in Germany and in many other countries.
But it might, you know, be an option. Or look for someone who just recently left a big law firm and is freelancing and, you know, needs new clients and new work.
And you can agree to work under the condition that the payment will come after the game is released. It's also a very common thing. You just need to find your lawyer who will be willing to work with you and agree
Yeah,
on
I think
those
the key
terms.
is actually knowing the person and having a relationship with the person. And
That's
a friend
important.
of ours recently had to file a lawsuit against a non-paying client, and the lawyers agreed to do it for free because we all play poker together, and we all felt that this is ridiculous that the guy doesn't pay. And the lawyers from a very expensive firm, they said, you know what, screw it, we're going to sue him. We're not going to charge you. And they sued and they won. They didn't even have to go to court. Once they sued, the guy saw the name of the law firm and he paid up. So that's an example of you know, that was a very small young studio that doesn't really have the money to afford lawyers. But if you connect, you know, this is called casual connect. If you connect, then boom, you know, good things happen. So I think we are over time. I don't know if you have time for one more question or not.
We're
We
going to
don't
stay
have-
here or in the lobby afterwards, so all the legal questions are very welcome.